Well, the court had the opportunity to sit through the trial and review the evidence in the case, and I've heard the statements related to the state's recommendations and to Mr. West. I'm not here, and I would not fault the jury concerning their verdict. They found you guilty of first-degree murder, and I've just sentenced you accordingly. I recognize that over the course of your life, you've apparently not had prior convictions, and that recognize many people speak very highly of the life you've lived and the things you've done. That always makes it more difficult for the court to understand how a person with a life of that nature turns down a path that ultimately leads to the death of another human being. 280 months is the presumptive sentence. I balance against that your lack of criminal history and the good things you've done. Counterbalance to that is the fact that although the circumstances may have resulted in a death that was unexpected in the sense that it may not have been what you initially planned to do, the indications are that faced with the consequences of committing felony assault in the beginning and then in the process taking a person's life, you engaged in some planning and deliberation in making sure that the death by strangulation was successful and that beginning the process of covering up. That sort of motivation, that sort of advanced use of knowledge related to the human body and what would and what wouldn't work to save a person indicates more culpability than the norm. Don't misunderstand me. A person has the right to enter a plea of not guilty and fully contest charges, and I never impose a sentence based upon whether or not they chose to plead guilty or go to trial. But the jury has found, and I concur with their finding, that in this case, your explanations don't make any sense. The only thing that makes sense is that you deliberately killed the victim in this case and ripped your family apart and created a great tragedy for a vast number of people as a result. So 300 months will be the sentence of the court. Given credit for any time you served, you'll be on community custody for the maximum period following that, and on the conditions suggested. Because of the length of your incarceration, I don't know your financial circumstances otherwise, are you indicating that restitution will be set in the amount to be determined, unless you have a figure at this time? With regard to other legal financial obligations, and the defendant contending that he's innocent?
He is, Your Honor. He was at one point deemed so by the Office of Public Defense, and I'll be addressing that with a motion to court later. But we would ask the court to find Mr. West he is
based on that, then, and the length of your incarceration and other circumstances, I don't impose any other legal financial obligations.
Thank you.
Are you requesting a no contact order with any member of the victim's family?
I don't know that that has been requested.
I'll advise you at this time that several consequences of your conviction. You may not own, possess, or have under your control any firearm, and under federal law, any firearm or ammunition, unless your right to do so is restored either by this court or by the court in which you're convicted, and by a superior or the Superior Court of Washington State, rather than by a federal court in some circumstances. If you have a concealed pistol license, you must immediately surrender it. You understand that? Also lose the right to vote. It will be a crime for you to vote until that right is restored by operation of law. Do you understand that?
I do believe there are going to be several requesting no contact orders from the health department.
And who are those people?
Officer Jim Nick.
Yeah, I don't believe that a basis has been established for the no contact orders.
What are the names of the people who want no contact orders?
Yes, is it Asha Mulder, who is the sister-in-law of Marcy, Jim Mulder, who is the brother of Marcy, and Megan West, who is the daughter.
It would be relative to the victim's family. It appears to me that no contact orders are appropriate, and you can submit them. Mr. West, I'll advise you at this time that you have the right to appeal your conviction and the sentence imposed if it's outside the standard range. Unless you file a notice of appeal within 30 days of today's date, you will lose the right to appeal forever. The court clerk, upon request, will supply you with a notice of appeal form and file it after you complete it if your attorney will not assist you with those things. Because you have the right to appeal, you have the right to have the cost of the appeal paid and an attorney appointed to assist you at public expense if you cannot afford those things yourself. And any petition or motion for collateral attack on this judgment and sentence, including but not limited to any personal restraint petition, state habeas corpus petition, motion to vacate judgment, motion to withdraw guilty plea, motion for new trial, or motion to arrest judgment, must be filed within 1 year of the final judgment in this matter, except as provided for in RCW 10.73.100 and RCW 10.73.090. Do you understand all of that? Yes. I signed the documents to reflect my rulings. They will be handed down to you for review with your counsel and what your signature and pencil indicated. That's for something else, I think, tonight.
No, Your Honor, just the no contact orders, so we'll get those, we'll take them out, and then
That's fine. If the objection is to the form rather than content, I can review those and come back out on the bench